Hello and welcome back to the channel. It's Stephanie again, and as always, we're happy to have you here. If you're new, welcome to SoLegal, a channel where we aim to explain law topics as well as offer tips to succeed as a law student. In today's video, we will be addressing how to answer law problem questions. And this is very much a big thing because law exams feature problem questions a lot, and many students seem to struggle with handling these type of questions. So in today's video, we'll talk about practical tips as well as the structure that you need to effectively address problem questions that you may come across in the exam hall. So let's get into it. Let's begin by imagining the scenario. You come out of the exam hall, you feel very confident, you knew all the answers, you remembered your cases, you knew the principles that applied, and you feel like you're going to smash that course. But then the results come out and it's not what you thought. Maybe you got a C or even worse. Well, what could have happened? The problem isn't your legal knowledge, it's likely your structure or how you approached your question. So we're going to try and fix that in today's video. We're going to go over the very popular formula, but a bit difficult to use for some students, I.R.A.C. So to begin, what is I.R.A.C? You probably already know the meaning of those initials. But if you don't, it means issue, rule, application, conclusion. It's a formula that is used to approach problem questions in law exams. It's a golden formula for law students. By formatting your answers using this structure, issue, rule, application, and conclusion, it makes it easy for you to include all the necessary points that you need to put in your answer. And it also helps your examiner or helps the examiner not struggle to find where you've left certain points in your answer. So in today's video, we're going to be using a practical example to see how to use the I.R.A.C rule. So let's begin with this one. Imagine this exam question. Imagine you have a question like this. It says, Mr. Tunde was arrested by the police on a Friday evening on suspicion of theft. He was locked in a cell and was not brought before a court until the following Wednesday. Advise Mr. Tunde. So here's the question. Once you see the question, the first thing you want to do is to identify the issue. So the issue is not a summary of the question before you, not a summary of the facts that you have been given in the question, but rather it's the determining of what legal problem needs to be solved from the question. So that's what your first sentence should do. You don't want to summarize the story. You don't want to give a very long introduction to start with. When answering problem questions, your issue is the introduction. So you may say something like, the legal issue to be determined is whether the detention of Mr. Tunde from Friday to Wednesday without being charged to court amounts to a breach of his fundamental right to personal liberty. That's it, one sentence. So when you see the question, regardless of what course your problem question is from, whether it's human rights as is this question, constitutional law, contract law, you are very likely to identify the topic that question has come from. And once you know the topic, you should be able to know what principles apply. So what issue would those principles that you can relate with, what issue would they resolve? That's what you're writing in your first line. With that, your examiner already knows that you know what you're talking about. You know what you're coming to solve in the question. So what I've read out is something somewhat of a blueprint. Some people would word it differently. You could say the issue raised by this question is ... You could just write that. You could also say this question presents the issue of whether ... And some people would just write issue, colon, and state the issue, whether. Note that some questions will have multiple issues. If that is the case, then you want to say the issues to be determined in this question are, and then you list them out, the 2 or 3 issues that may be in the question. But the question we're using right now has just one issue, and we've identified it. After stating the issue, you're not explaining anything. You're going right ahead to state the rule that is applicable. So this is where you bring in your statutory and judicial authorities. Statutory authorities would be your authorities that are found in statutes, in acts and laws, whereas your judicial authorities obviously are case law. And here you are just stating the law. You're bringing to fore the cases that apply, the sections of acts, laws, or the constitution that apply to the issue. So in this case, you could say under Section 35, Sub 4 of the 1999 Constitution of the Federal Republic of Nigeria, any person arrested or detained must be brought before a court of law within a reasonable time. You could proceed to include more sections, such as Section 35, Sub 5, that defines what reasonable time means, which would be 24 hours if the court is within a 40-kilometer radius, or 48 hours if it is farther. So now you've stated your statutory authorities, which is from the Constitution. You'd also want to, at this point, bring in relevant cases. So relevant cases with regards the principle of personal liberty could be Jim Jaja and COP. You have Lufadejo and Johnson. So what you want to do when you're bringing in your judicial authorities is you want to pick out the ones that are most relevant to the facts that have been given to you. So you mention this principle was espoused in the case of COP, Jim Jaja and Commissioner of Police, where the court held that. Or you could say a relevant judicial authority that relates to the set of facts before us is Lufadejo and Johnson, where ABCD happened and the court held EFG. So that's how you want to frame your judicial authorities when you're using them in the rule section of I.R.A.C. You're not applying it yet. You're just laying the facts, laying the law rather in that section. Section this of this states this. Section this of this also states this. In this case, this happened and this was held by the courts. In this case, this happened and this was held by the courts. And that's what you're doing for the rule section of I.R.A.C. And now you're leaving your application or any analysis that you're doing to the application segment of your answer. You've gone through your issue, you've gone through your rule, and now it's time to apply those laws, those rules or principles to your set of facts. And before we proceed to the application, we should know that when you're stating your principle, such as in a question like this, if there are applicable exceptions, you need to state it in your principle, in your rule. So for instance, the general rule is that people are guaranteed the right to personal liberty, but there are exceptions. So you would want to state your exceptions under the rule section of your answer. If your principle relates to a right, you could state the right and then state the exceptions under which those rights could be derogated from, right? So that's what you're doing when you're answering questions. State the rule, and within the rule, if there are applicable exceptions or conditions that need to exist for that rule to apply, you're listing it in your rule. And then you move on to application. So under application, and this is where most students miss it actually, because they state the rule and they just conclude, they do not apply. But those several lines of analyzing your facts as against your applicable principles, those earn you a good percentage of your marks. So don't forget to apply. So now we're tying the rule that we've stated to the facts given to us in the question. You could say something, you could write something like, applying the rule to the facts, Mr. Tunde was held from Friday to Wednesday, a total of 5 days. So notice that we're not just regurgitating the facts that were given to us in the question. We've now done a little analyzing that Friday to Wednesday amounts to 5 days. Proceeding, we're saying, even factoring the weekend, this far exceeds the maximum 48-hour constitutional limit stipulated in Section 35. The police cannot justify this delay as reasonable. So again, you see what we did here. We didn't just state the law, neither we just reproduce the facts, but by analyzing the facts and tying in the law, we've shown the examiner that we know how the law interacts with those facts that we've been given. We've linked it to that specific 5-day timeline that was given to us in the question. So now that we are done applying, we want to conclude. So again, if there are relevant exceptions that work here, this is where you bring in the exceptions to the facts. So if, for instance, you are addressing the right to life, the principle governing the right to life, and there are exceptions, which they are, that allow the right to life to be derogated from. Say the question had given you something about a person being executed, a case of enforcement has been brought before the courts, and you want to now analyze, you're asked to analyze whether the execution was proper. So it is at this stage of application that you want to say that although the right to life is guaranteed under the Constitution, carrying out an execution pursuant to a conviction by courts for a capital offense falls under the exceptions to or the derogation from the right to life. So you want to tie that in your application. And once you've applied, once you've had your couple of lines or your paragraph tying in the facts to the principles that you already stated, you want to do what's very important, and that's to conclude. Again, many students, they apply quite all right, but then they just stop midway and end. But that's not proper. You should conclude. And that's why this formula I.R.A.C is very important. It helps you remember that, oh, I have applied, but I have not concluded. Oh, I wrote my rules and I'm going straight to conclusion. Something is missing. The I.R.A.C rule is very, very helpful. So concluding, we want to wrap up everything that we've written with the conclusion. And you want to keep your conclusion comprehensive. You want to make sure that it addresses the relevant issues. So if you had addressed issue 1, rule, application, issue 2, rule, application, you want to conclude including all those issues that you've already addressed in your question. So for our example, our conclusion will read something like, in conclusion, Mr. Tunde's fundamental right to personal liberty has been unconstitutionally breached. He is entitled to seek redress, including public apology and compensation from the police, pursuant to Section 35 sub 6 of the Constitution. And that's how we are ending. Remember that the question says you should advise Mr. Tunde. And so this brings to mind something that is very important that you should note regarding conclusions. Your conclusion must address the question. So if the question asks for you to discuss the propriety of an act, then you should conclude by stating that that act is proper or it isn't proper. If in the question you're being asked if a statement or an action is valid, then that's what you should be answering in your conclusion. In conclusion, so dash statement or dash act is invalid pursuant to dash authority, right? Likewise, if the question asks you to advise a party, as this question did, then that's exactly what you want to be doing in your conclusion. So when we said he's entitled to seek redress, including public apology and compensation, a better way to frame it would even be, thus, Mr. Tunde is advised that he's entitled to seek redress. So it's always good to reflect the actual question that you were asked in the question, reflect it in your conclusion. It helps the examiner know that, oh, this person is addressing the question that he has been asked. So that's it. Issue, rule, application, conclusion. It's quite straightforward. And when you structure your answers like this, you make it easier for yourself to write clearly. And you also ensure that you are including the relevant aspects of your answer. You notice that when we followed the formula, it helped us not miss our application or miss our conclusion, which are very key aspects of answering or addressing any problem question. And of course, it will help your examiner know where to go to find certain aspects of your answer. So if your examiner at that point is trying to see if you raised the correct issue so as to award you the points for the issues, he knows that he's going to the top of your answer. If your examiner is looking for the rules that you've stated, if you've mentioned maybe the locus classicus related to that issue, he knows that he's going to the rules section of your answer. So it really helps provide structure to problem question answers. But then knowing the structure, knowing I.R.A.C for problem questions is just half of the battle. You still need to understand the actual rules, whether it's constitutional law or human rights law like we've addressed, or if it's contract law, Nigerian legal system, or other core law topics that you take. One thing is you don't have to figure it out alone, and that's why at SoLegal, our virtual tutoring sessions break down complex law topics across different law courses. We also provide detailed notes and review materials that would help you prepare effectively for your law exams. So if that's something you're interested in, you might want to check out our website and see our tutoring packages. And if you join our online community by subscribing and turning on your post notifications, then you get to see our explainer videos when we put them up once a week. And that's pretty much it for I.R.A.C and today's video. Drop a comment if there's a particular law topic that is giving you a headache, and we'll see if we can put up a video in the coming weeks relating to that topic. And thank you for watching. Stick around. We hope to see you in our next one. Bye.